The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon, ladies and gentlemen. Welcome to TechGig webinar series, our endeavor to empower techies. We believe that sharing of knowledge is the key to enhance our skills and grow us as professionals. With this principle in mind, we have initiated a series of webinars conducted by industry experts to give you all a crisp insight of various domains. The topic of today's session is Relevance of Intellectual Property for Indian Software Industry. Our guest speaker today is Bindu Sharma. She is Vice President Head Legal Services at Origin IP Solutions LLP. Bindu Sharma is patent attorney and a registered patent agent at Indian Patent Office. She has been practicing in IPR for past 7 years and has vast experience with IP audit, formulating IP policies, patent specification drafting, prosecution, copyright, design, and contract law. She has been speaker in several workshops, conferences, and has provided several IP sensitization programs to corporate and academics. She has several publications in her name and has authored books such as India's first dictionary on patent law and handbook of IPR. Origin IP Solution has been finalist in ET Now Leaders of Tomorrow Awards 2013. So, without further delay, I introduce you all to our guest speaker. Over to you, Bindu.
Yeah, thank you so much for the introduction and a very good evening to all the participants. So I will be specifically talking about relevance of intellectual property for Indian software industry, because Indian software industry, I feel, have that feel that IP is not relevant for them, specifically when they are providing services and they don't own products at the end of the process. So let's have a look at what actually is intellectual property. So as the name suggests, intellectual property means creation of mind, and creation of mind can take various forms such as a painting, a drug formulation, a software, automobile products and all. So and it is important to note that any form of intellectual property gets protection only upon registration. That means that even if you have a good product, but product is not registered or well protected, and it is released in the market, then you cannot stop people from copying your product. So in order to have value in your product, it's important that you register your product under appropriate law. And once you protect it adequately, then you have ownership over the product and you can actually possess it like any other tangible form of intellectual property. Now, looking at the Indian Constitution and US Constitution, just a comparative account, in US Constitution, there is a specific mention of scientific innovations and discoveries, inventions. But US Constitution says that Congress shall have power to promote the progress of science and useful arts by securing for limited times to inventors the exclusive right to their discoveries. Now, looking at Indian Constitution, we don't have any specific mention of the word intellectual property, but we have a mention of word property. So all the traits of the word property have been assigned to this word intellectual property. Like you can possess property, so you can possess your intellectual property. You cannot be deprived of your property. You have all the rights to own a property. So similarly, you can own your intellectual property. Now it's interesting to note that when the flyovers are getting built and any property, public property is in place, then government can acquire that land in order to make flyover for public purpose. So similarly, if any IP is important for government, similarly government can also acquire your intellectual property for public purpose upon payment of a compensation. So now looking at various kinds of intellectual properties that we have, so it is a bouquet of flowers. So patent is king of IP, and whenever we talk about patents, the discussion is incomplete without specific emphasis on patents. So patents are very important because patents protect your product very extensively, and patents are for the inventions. So when we say inventions, that means a product or process That is not there in the globe right now, and you are the first one to come up with that particular product or process, and that is what makes patent law very distinct from any other form of intellectual property. So when we talk about patents, we should always relate patents with the inventions and not discoveries. And a patent has a specific life of 20 years, and after 20 years, patent gets expired. That means you can use that particular patent without any formal consent of a patent holder. So then next form of intellectual property we have is copyright, which is extremely important for software industry because you have lots of software programs and source code, algorithms. So all that is covered under copyright law. And life of copyright is very long. It is 50 to 60 years after death of the last author. Then the next form of intellectual property, you are very familiar with this, that is brand name or trademark. So brand name or trademark is nothing but name of your product or name of your business. So if you are into services, then the trademark is called a service mark. So if you are in the business of products, then it becomes a brand name or trademark. And life of a trademark is perpetual. That means as long as you are maintaining it by paying renewal fee to the trademark registry, trademark is enforced. So, and if you fail to pay renewal fee in time, then trademark can be abandoned by the trademark registry. Then we have next form of intellectual property, designs. So design is very interesting form of intellectual property where the apparent look of the design gets protection. So there are a couple of products in the market which you as a customer solely buy because of apparent look, irrespective of the functionality, irrespective of the technology running behind that. So design, apparent look of the product gets protection under design law. Then we have separate law for semiconductor chipset design. And geographical indication, next form of IP, geographical indication is again interesting form of IP, which is like specialty of a place. And I'm very happy to share that Karnataka is the state with highest number of registered geographical indications in its name. So when I say specialty of a place, then it means saffron from Jammu Kashmir, then you have Himachal apples, then you have Nagpur oranges. So I'll show you a couple of registered geographical indications from Karnataka. This particular variety of banana is a registered geographical indication. Then this is called as Kasuti embroidery. This again is geographical indication from Karnataka. Then I'm sure you all know this is Chanpatna toys, specialty of Mysore. So this again is a registered geographical indication. Then the specific variety of pan leaves, betel leaves is registered geographical indication. Then there are several products made of sandalwood which are registered, sandalwood agarbatti. Then we have sandalwood oil, and then we have sandalwood soap. So there are several products of sandalwood which are registered geographical indications, and they have been registered in Karnataka itself. This is Mysore sandal soap. Then is trade secret or confidential information, which is extremely important to a business, but unfortunately this is a kind of intellectual property which is ignored by most of the businesses, and you realize importance of trade secret only when it is lost. So there is no specifically law to protect trade secret in India, but you have to take all the precautions to keep it a secret, because once secret is out, then there is no way to get that secret back. And then we have next form of IP, traditional knowledge, which is nothing but grandma's recipes. You have ginger honey for throat problems. So all these kinds of knowledge which gets accumulated in a society is called as traditional knowledge. And there is specific mention of traditional knowledge in patent law, which says that there cannot be any patents on traditional knowledge. And India is a unique country to have one of the very few countries in the world to have separate law for new plant variety protection and farmers' rights. and we get protection for new plant varieties under this law. So for any software IT industry today, the relevant form of IP could be one is patent. Even though you are not filing for patents and patent filing is not in your business strategies, still it makes lots of sense to know about patents. I'll explain you in next slides how patents are still important even though you are not filing for patents right now. Then is trademark is important for your new products, processes, and I would like to specifically emphasize here that when you have a new trademark, just have a search done before settling to the new mark to make sure that it is not similar to any existing mark. And then when you start using the trademark, just put TM over it. And after the trademark is registered, you can put small r as superscript over the trademark. That serves as a legal notice that it is a trademark of the organization. Then we have copyright, which is very relevant for software industry, and then we have confidential information, which again is important for any industry. Then we have trade secrets, and then the domain name. So domain name has very close resemblance to trademark, and in many of the cases, domain name infringement cases have been dealt under trademark law. So then there are a couple of issues when we talk about intellectual property with specific relevance to Indian software industry. And one of the these all observations are based on my experience. So so IP is not on top priority for the industry today for various reasons, and one of the prime reasons for this is that Indian industry is still heavily based on the services, and even though transition is happening from services to products, but still big chunk of it is service based. So when you are providing services to your clients, then you will definitely sign a service agreement which says that all IP generated in the process belongs to the client, and then you don't have anything at the end of it. So that is one of the core reasons that IP has not been on top priority. Then IP is still seen to be expense rather than investment. So we have to build an environment where IP is seen as investment and not expense, and it should add to your intangible assets. Yes, industry is primarily service-based. That is one of the sole reasons for IP not being on top priority. Then service agreement says that IP belongs to the customer, and that's what makes you feel that there is no point knowing much about IP because you don't own IP, so you don't need to care about it. Then it is a well-known fact that softwares are very difficult to get patent, especially in India. So that is again one reason that discourages the industry to file for patents or even think of patents down the line. So but my observation is that scope of IP is much beyond patents. So even though you are not filing for patents, understanding IP is still very important, and it can benefit your organization in multiple ways. So we'll just see that even though you are not filing for patents, then IP is important for you in multiple ways. So I have gathered a couple of issues or maybe a couple of questions, and I feel that that contract, as per the contract, who owns the IP once software company enters into work for hire contract. So this is one of the frequently asked questions who owns IP. So now I would like to tell you here that when you write a code and you make a software, then there are two kinds of IPs that come into picture. One is copyright, and then second is the patents. When I say copyright, I mean to say that you have developed a product wherein the copyright lies in the source code. Now, who owns that source code is a very difficult question, because copyright law says that if you contract a person, if you commission a person to make product for you, and that product is likely to be protected under copyright law, then it comes under work for hire doctrine. That means that you have paid a person for the work he or she has done. Then you become owner of the product because you paid for the work that you got done, and then IP in the process, IP also belongs to your customer. So that actually is correct. So copyright on source code, if specifications to prepare that product has been provided by the client, and source code has been written by you, and you got paid for whatever work you have done for your client. So that comes under work for hire doctrine, and your client becomes owner of that product. But in order to register that product, there are a couple of procedures. Then algorithm, if there is algorithm in the product, then algorithm can also be copyright protected. So copyright comes under work for hire doctrine. So then is invention. So how does invention come into picture in case of software as a product? Suppose you are providing a solution to your client, and at the time of providing solution, you come up with better process to provide the solution. So in that case, there are chances that you invent new way of performing a particular task, and that particular task may be called as invention as per definition of invention under patent law. So when you come up with better method to perform a task, and if it is subject matter of patent, then ownership is a very difficult question. And if you look at legal part of it, then a person who invents becomes the inventor, and his name has to come on the patent application as the inventor. So irrespective of the fact that the work has been, you are providing services to your client, but you invent something in the process, you have all the rights to be called as inventor. Again, even though you are inventor, you have to really see that who is going to own that particular patent, and there are various kinds of methods that can be worked out between you and your client. We have tried this in a couple of cases, and very successfully we could convince the clients to have a percentage in the patent, and the vendor has applied for patents. And you can also have a system wherein you file for a patent and provide perpetual license to your client. So in that case, the IP which is developed in the process of providing services, and such IP gets protection, and you and your customer can jointly own or own IP over it. So these are a couple of the way outs, and it's important for us to understand that copyright law protects only expression of the idea and not idea itself. That means a particular software has a function. It is meant for a purpose, suppose a banking software. So the theme of the product, that is banking software, is idea. So idea does not get protection. The way you have written the code is what gets protected. So a person A has a particular way of writing the expression, so that person has its own copyright. Then second person, even if second person writes code in its own way without looking at the code written by person A, then A and B, both of them, they can have their own separate copyrights without infringing copyright of each other. So there is a very thin line between idea and expression, but yes, copyright protects only expression of the idea and not the idea itself. Okay, then the second issue here is that who owns software framework and processes, and the answer for this question is, now you know very well that framework is abstraction in which software providing generic function can be selectively changed by additional user written code. So framework is a very good thing in the sense that it saves lots of your time and it prevents the redoing of the same work. So now who owns the frameworks that a company owns? So in this case, we have to analyze whether framework is worth calling intellectual property or not. So if the framework is subject matter of copyright, then we have to see whether it fulfills requirements of registration for a copyright or not. So if framework is a part of invention, then again it has to be verified by means of checking eligibility criteria for the patent. So and patent and copyright are the two forms of IPs that can come into picture while protection of a framework. And it's important here to understand that if you feel that framework is innovative, if you feel that framework is not copied from any source, if you feel that framework is really innovative, you should analyze how to protect that framework, and it is very important to register your framework under appropriate law so that you have rights over your framework and you can prevent others from copying your framework. And in this case, if you own the framework, you can always wrap around your services around your frameworks and serve it to your clients. So reusability becomes quite easy when you have ownership over the frameworks. Then it's a very common problem that third party's IP is used by mistake, accidentally by any company to deliver its work product. So if you don't protect your IP, it's fine. Maximum consequences that you lose rights over your IP. But if you infringe upon, if you encroach upon any third party's right, then you may be in big trouble. And using third parties' IPs without permission, with or without knowledge, may be deemed to be infringement of IP rights. Then there are lots of things to be taken into consideration. So initial due diligence is very important to avoid surprises in future and minimize the risk of IP infringement of third parties. There have been cases where Indian vendor makes a software and supplies it to client in US, and its US client gets legal notice from companies in US for patent infringement matters like that. So then the next issue is usability of open source software and ownership of IP, and especially when your IP, you come up with a product and product is built using open source software. So in that case, your product is a mixture of open source software and it's a mixture of something which you have invented. So now having clarity on IP rights in such a case is very critical, and it's so in such a case you need to segregate very clearly that what is the stuff you have taken from open source and what is the sole IP that has been developed by you. So once you segregate this, you also need to read the license agreement, because even though you segregate open source and IP developed by you carefully, you cannot ignore the fact that product does not work without open source. So it is a combination of both. So it is important to read the license agreement. I know few people, very few people read the license agreements, and it's not very interesting to read license agreement. Once you draw line between open source and your own innovation, then it becomes easier for you to decide on the kind of protection you need for your own innovation. And if you're filing for a patent, it's not very difficult to just claim rights over your own innovation without touching upon open source. Then identification of legal regime to protect your product properly is necessary. Then most frequently asked question is that if not patent, can we apply for copyright? So I would like to clarify here that even though you apply for copyright or patent, but copyright is not a substitute for patent. So you have to understand clearly that when you are filing for patent, you are getting entirely different set of rights. And when you are filing application for the copyright, it is entirely different set of rights that you get, and it's possible to have both for a single product. So one product can have multiple kind of protections. So difference between copyright and patent has to be understood clearly. So the patent protects the concept, but copyright protects only expression of of the invention. So that is the sole difference between patent and copyright, and without this goes without saying that patent is much stronger protection compared to copyright. And independent creation of copyright work is not legitimate. That means two people sitting in different parts of the country writing identical code, but without looking into each other's work and without having met any time in their lifetime, they can claim copyright on the work independently. So it is not infringement if the work has been created independently by both the creators. Now, how to minimize IP infringement risk and make use of state-of-the-art to fine-tune the services or the products. Minimizing IP infringement risk or assessment of infringement risk is very important, because while working on your projects, you might accidentally encroach upon third parties' rights, and this can land up in a big trouble. So protection of own IP is very important, but at the same time, it's even more important to take precautions not to infringe any third parties' rights. So I'll just give you an example. Suppose your invention relates to screen display of a cell phone. Okay, so you are inventor of screen display of a cell phone, and you file for a patent for this particular technology. And screen display is something which is applicable to cell phone, or it is applicable to television, or even laptop. So now you have protection upon only one feature of the cell phone. Now having patent for screen display does not give you right to manufacture the cell phone itself, because other components of the cell phones might be patented by any other company like Apple or Samsung. So in order to manufacture the product, clearance search is extremely important, so that accidentally you don't infringe upon any third party's rights. So this kind of due diligence is necessary not only for the products but also for the processes. And this actually gives you so much of mental peace in terms of minimizing the IP infringement risk. So due diligence or clearance search shall be done right in the beginning before actually starting the actual work. So by means of doing various searches, you identify the documents which you are likely to infringe, and you just see how many components of your product match with the IP, and this way you can actually minimize infringement risk. And if you are likely to infringe any patent or any other form of IP, then there are way outs to overcome that issue. That means you can either take license from IP owners, or you can work around in such a way that you don't encroach upon any existing IP, or you can also decide to take a bypass route where you don't touch upon any existing product or process. There is one interesting example wherein Anand Electronics and Futuristic Concepts Media, they were using digital transmission system technology to manufacture VCD, and they had no clue that they released a product without any formal due diligence, and they didn't know that Philips already had a patent on this particular technology. So Philips, when got to know about this particular product, they filed for a case, and Delhi High Court ordered 2 Indian companies to stop manufacturing the VCD that infringed Philips' digital transmission system. And the lesson to be learned from this case is that using technology which is protected by another company can drive you out of business, and hence it is very important that you do your initial due diligence and see that and confirm that you are not infringing or encroaching upon any IP rights of third parties. Then this is a recent case. This took place. This is a recent case which took place way back in November 2013, and this is between Apple and a very small company called Vernatex. Vernatex is a small company, and they had 4 patents, and the 4 patents related to FaceTime video calling services. Apple happened to implement or use these 4 patents in FaceTime video calling services that is there in Apple products. And when Vernetex got to know about this infringement of patent rights, they filed for case against Apple, and then this company could manage to have huge amount of revenue, that is 368.2 million USD from Apple, and this was actually a huge amount for them. And this Vernetex is a small company with very meager revenues, and the kind of damage they got from Apple was multiple fold of their annual revenue itself. And IP cases have been most expensive cases in the history, and if you look at the top damages that have been awarded in the past, it is actually phenomenal. So it is another reason for any industry or any organization to take initial measures not to infringe upon any third party's rights, and having initial due diligence done can save you from big trouble. Okay, then I feel that confidential information or trade secret is a kind of IP which is often ignored by the businesses, because the first reason for this is that they fail to realize that it is confidential information and it needs kind of protection. So, but unfortunately, confidential information once lost is lost forever, and there is no way to recover it. But there are ways to protect confidential information. You can have various processes to protect this kind of information. But before protection, it is important to identify that this information is critical for the business. So confidential information or trade secret is sensitive information related to business and technology. It is extremely valuable business asset. And the best way of protecting confidential information is, first of all, identify it, then segregate it into low, moderate, and high confidentiality. And you can always label your soft files as confidential, and if it is hard file, while communicating that file to your colleague or any concerned person, you can always mention that this is confidential, because at the time of communication, you have to actually mention that it is confidential. So even though there is no mention of confidentiality, or there is no written word like confidentiality on the document, but being a person, being the educated person, if you can sense that document is confidential, you should handle it with care. Physical procedures and sensitization works very well in the protection of confidential information. And unfortunately, once it is lost forever. So one has to be very, very careful, and there have been several cases where misappropriation of confidential information has taken place. Ex-employees, they have stolen some kind of confidential information and taken it, and unfortunately the kind of agreements your employees sign at the time of joining the organization, they are never made understandable to them. And as an employee, you always have right to ask for legal assistance if any clause of the agreement is not clear to you. So just check whatever documents you have signed, and you will find the explanation of what is confidential information as per organization's policy. So I will again emphasize here that scope of IP is much beyond patents. So you can still make use of IP in multiple ways. So some of the ways I have listed out. Now, you can always strengthen your core technologies by means of using intellectual property in the form of patents, which is available. Suppose you have a product, so you can identify the patents that relate to that particular product. And if you are using those patents in the territory of India, and there are no patents in India but in other countries, so you can always explore the way to use or implement those patents. So this kind of work actually can add, this kind of exercise can add lots of value to your products and your processes. Here I would like to emphasize that this talk is to give you overview of intellectual property, and for specific infringement related matters you need to seek legal assistance. You should not use any patents without any due diligence done right in the beginning. So knowing IP can make lots of difference by when you know what is IP, what is not IP, you can minimize IP infringement risk, and you will also realize that there are lots of things you can use, but you have not been using it, fearing if the infringement will happen, this will happen, that will happen. So understand the subject so that you can make use of intellectual property which is available for free, and you also assess the chances of minimizing IP infringement risk. Then suppose there are 4 or 5 core technologies in your organization. So you can always opt to get patent alerts for that technology. If you are in automobile, you can just list out top 10 automobile companies, and you can observe their patent filing trends every quarter or every half yearly. Similarly, you might be having some good technology like IPRs. So you can opt to get patent alerts, and every 3 months, 6 months, you can get whatever latest patents have been granted or published in the technology like IPRs. So this kind of study helps you to get updates on evolution of the technologies, and you are also in touch with latest happenings in that area of technology, and you can understand your competitive strategies and all in much better manner. And while listing out such patents, you might come across interesting patents which are not filed or granted in the territories of your choice, territories where you have business. In that case, you can always think about using such patents or maybe opting for licensing those patents. Then in India, most of the software products are not patentable till the time, but a software that has association with any tangible device, or in other words, embedded software, are very much preferred for patenting in India. But otherwise, core software are not patentable in India. So that is that actually stops you from filing for patents in India. But if you look at other side of the coin, then if you pick up any interesting patents in India, you can always verify whether it will be granted in India or not, so that you can think of making use of that patent if required. Now, IP is excellent tool for protecting your products, and it is very important to enforce your right. If your product has been copied, or if the copyright has been infringed, you cannot even file FIR without having copyright registration done. So it is a tool for protecting and enforcing your IP rights, and it is very, very important for brand building. So it can be one of your organization's good marketing strategies, or it definitely helps you to build your brand. And it is interesting to note here that once you file for patent, even though it's not granted, you can label your products as patent applied for, patent filed, patent pending. So that gives you good marketing strategies. Then IP is intangible asset, and at the time of acquisition or merging, it can add lots of value to your organization. Value of organization today is assessed mostly on the basis of intangible assets that one has. And any form of IP that you own today, you can always consider that to be sold as and when required. So with this, I conclude my talk. I feel even though software is not patentable in India, even though software industry is heavily based on services, but still IP can add lots of value to your business. You can assess infringement risk. You can make use of IP which is available to be used, and there are lots of expired patents, abandoned patents that you can always think of using. And small things, if done in everyday life, they help you to maintain IP hygiene in the organization, and you can certainly make use of information in the form of patents, which might be available free of cost. And it is extremely important to understand power of state of the art. I mean to say here is that before inventing further, before developing your products further, it's important for you to know what work has been done already. You can definitely build your product in much better manner once you're thorough with state-of-the-art studies, and you know what others have already done, so that you don't land up inventing the wheel again. And apart from reinventing the wheel again, you might be infringing any third party's rights also in the process. So understand the work which has already been done, and based on that, you can develop your product further. So with this, and just one slide about my organization, Origin IP Solutions. We are Bangalore-based IP firm, and we offer services in the area of patents, copyright, trademark design, and contract law. And we provide end-to-end solutions and services to our clients, starting from the idea stage itself. We help them in documentation of the idea, then initial analysis of the idea to guide them what is the best way of protecting it. So once it is protected, how to exploit it, how to monetize it in effective manner. So we want, we work with a prime mission that we want to enable our clients to realize long-term value and benefit from IP by identification of IP, exploiting and managing it in best possible manner. And we also believe that we should contribute to the society and nation by making the industry and academia aware about legal provisions and concept of IPR in a simplified manner, thereby enabling them to secure and exploit IP in much effective manners. Thank you very much for your patience hearing. We can take up a couple of questions from the audience now.
Yes, Bindu, thanks for the insightful presentation. Let's quickly take up the questions. I request you to read out the questions and their answers so that all our users may listen to the insights. Are you able to access the questions, Doc? Bindu, can you see the questions doc in the control panel?
Yeah, I can see.
Okay. Just like we did in the beginning, you just need to drag it out of the control panel and expand it.
Okay. Yeah, I can see it.
All right. So we have a lot of questions from the audience.
Yeah.
So you can start.
I'll read out the question.
Yes, please do, Bindu.
Okay. The first question is, I'm a functional consultant making the design of functionality, which was coded by a developer. I finally do the unit testing and approve. Who is owner of IP in this case? So in this case, I feel it comes under work for hire doctrine. And just a minute, so I feel in this case, when you have paid for the work which has already been done, then the person who is paying for the work, it comes under work for hire doctrine, and the person who is paid for the work can be owner of this IP, and you would require NOC non-objection certificate from the developer in order to register copyright wherever you want. Then second question is, can same idea or work be patent for solution provided and copyright for the client? Can the same idea or work be a patent for solution provided and copyright for the client? Yes, it can be. It can be certainly. One product can have multiple kind of protections. Like if you look at iPad. So iPad has apparent look of iPad is design, then internally how it's working maybe a patent, and the kind of manuals they have or user interface they have, that can be copyright. So one product can have multiple protections. So the third question is, I have heard that software alone cannot be patented. It has to be attached with a device. Can you brief about this topic? This is actually right. Embedded software is very much preferred by Indian Patent Office for patenting, and software alone is very difficult to get patent in India. But if you have market in US, you can always think of having the software patented in US. Then next question is, fourth question is, how can I see the expired patents? Yeah, Uday Anand. So Uday, you can actually, there are a couple of databases. In fact, every country maintains its own databases. So you have to, there is nothing like specifically you will find expired patents there. You have to search patents of your choice, and then for each and every patent you have to check legal status to ensure that it is expired or it is enforced. And at times you consider a patent to be expired, and later you see that it gets revived also, because there is a buffer period which is given by the patent office that if you have failed to pay any particular fees, you have chance to revive the patent. So before using such patents, you have to be absolutely sure that there is no chance of revival. Then the next question is, can the same idea or work be patent? This I feel we have answered already. Yeah, this is answered. Can you please explain how to conduct IP audit and who are the right people to do such audit? Shweta. IP audit, actually, we do IP audit for the organization. So IP audit has a purpose. At times, IP audit may be required to see what are the flaws in the process. And at times, IP audit might be to segregate the IPs you have and find out whether you are not missing any timeline and all. So IP audit has a purpose, and you might also consider identification of new ideas, documenting them, and checking under what legal framework it should be protected. So a person who will do IP audit should be a person who comes with good experience in legal part of it, technical part of it, and that's how IP audit is done. Next question, how to perform clearance search? I mean, is there any central location where one can go and perform clearance search? Manish, when we do clearance search, suppose, again, I'll take the same example. Suppose I have come up with GPRS, some advanced feature in GPRS feature, and I want to use it for the cell phone. So I have to pull out all the patents that talk about that particular technology, and then I have to map with my product, and then see what are the chances of infringement. And clearance search is a long procedure. It takes time, and it should always be done by the expert, because opinion on infringement is very critical for any business. So one has to be really careful while using results of clearance search. Then next question, Rekha Rao. How important is novelty search when we do a provisional patent filing? What if we skip it and do provisional filing? Is that okay? Novelty search is, at the time of filing provisional application, novelty search is important because it's good for you. By doing patent search, you can actually improve upon your idea. So even though you don't do novelty search at the time of filing provisional application, it's okay. But later, if you find any good prior art which was very close to your product, then it's difficult to go back at times. So it's always recommended to have patent search done before provisional application. But again, it's not mandatory. You can always take a decision on filing patent application and then file a complete application within 12 months time. Then second question from Rekha Rao, difference between novelty search and clearance search. The novelty search is to assess whether your invention is novel. Clearance search is necessary to ensure that you are not infringing any third parties' rights. Then third question from Rekha Rao is, if I commercialize the invention right after provisional patent filing, is that possible that invention gets involved in infringement risk? Yes, it is possible. It might happen because when you commercialize your invention, you are not aware of the existing patents. And infringement analysis or infringement risk is always done in the given territory, in the sense that if I have business in India, I should be checking only Indian patents. If I don't have any business in the US, there is no point to look into US patents when it comes to infringement risk analysis. Then next question is from Mr. Ram. Could you please explain infringement in terms of claims? For example, if patent has 3 claims, and if I use new method I use a new method D, D in place of A, meaning I use B, C, and D. Is this infringement? It is difficult to give answer of this question in terms of yes and no. But while doing infringement analysis, it's important to focus on the independent claims. And till the time actually proper due diligence is done, it is difficult to give answer in yes and no. So then, Mr. Vinod, you mentioned about setting alerts for patents. Where do you set them? If the patent alerts have to be extracted manually, manually based on either technology or based on your competitors. So it has to be done manually, and any IP firm will provide you these alerts on monthly or quarterly basis. But patent alert is one very good way of getting in touch with the latest happenings in a specific area of technology. Then submit. Hi, in a contract, if development is done on the customer's network platform, does the IP of code or software belong to the customer, or does the vendor have any IP control? So I feel in this case, your customer will be owner of this IP because development is first of all done in customer's network, and again, it looks like that this particular work will come under copyright. So if it comes under copyright, then it is work for hire doctrine. Then Vinod, next question. How easy it is to get a software patent? In US, it's fairly easy, and in India, it's a bit difficult, honestly speaking. In India, there have been lots of objections on software patents, and recently Indian Patent Office, they have released guidelines for software patents. So if, I can share it with you, otherwise you can just type Indian Patent Office on Google, and the first link you get is Indian Patent Office, and there you will see notifications, and they have given guidelines for software patents in India. Next question is from Smita. How we will know if someone is misguiding public or their compilation competitors for their unregistered copyright or patent, telling they have copyright or patent already? And this again is, you know, as IP owner, you have to be vigilant first of all, and you can check these things only when you are vigilant. Because in order to enforce your rights, you have to do this homework before taking any further action. The next question is from Prashant. I'm from National Law University, Odisha. We are using IP access of library research databases, which can be used in LAN. If we will extend the access using VPN, access will be from same set of users. Will it be illegal? Prashant, I need to check it actually in order to give you specific. In order to clear this doubt specifically, I need to actually work a bit more on it. So I'm sorry. Right now, I cannot answer this question. Next question is again from Smita. What is the term valid after patent revise? Is it same as patent at first time? Life of patent is 20 years from the date of filing, and I am not understanding what is meant by term valid after patent revise. So once this 20 years term expires, patent is in public domain and people can use it without your consent. So first part of the question is not actually clear to me. What is term valid after patent revise? Okay, then next question is from Dheeraj. I'm giving many ideas to my company but don't know how to patent it. Any idea? Now you have to see the kind of IP policies, if any, you have within the organization, because if you're giving your idea to your company, there has to be idea disclosure form with your company, and you should get recognition for that particular idea, so that tomorrow if your company plans to file for a patent or any other form of IP, your name has to appear. On the application. So it's important to look into the internal policies your organization has. Are there any more questions?
There are a few more questions, Bindu. Are you able to see them?
Yeah. Well, I'll scroll down just a minute.
All right.
Yeah. There are questions. Okay, the next question is IP alerts. Can they be set in tools like Google, like using keyword search? See, patent search is very different from keyword search. I'll give you an example. If I have to search for patent alerts for the product called mouse, computer mouse, and I do Google search, then I will come across hits like mouse trap and mouse feed. So while doing patent search, you have to be very specific, and every invention or every technology has a particular classification, like mechanical devices, computer products, then pharmaceutical products. So when I say mouse, I have to use the classification code that is specifically for this product called mouse, computer mouse. So otherwise, you put any keyword and you will find hits in lakhs. And then when we talk about alerts have to be time specifically from January to March, because you will not be interested in alerts which is like for 2 years back or 3 years back, because the main idea of having alerts is to have latest information on happening in the technology. So Google is not good search engine to go for patent alerts. However, you have to have some paid databases or specific databases to do a search on patents so that you get relevant patent alerts. Next question is from Vinod. Even if I find an infringement done by third party, the amount of time to prove the same in Indian courts is very high as compared to US. Vinod, you are right. Time taken is very high, and that is one of the reasons that in maximum cases you will see out-of-court settlement happening. So you are right, actually the time taken is very high, and especially Indian courts and Indian setup is not as mature as the US. So there are lots of flaws in the system right now. Then Sriram, next question is from Sriram. In spite of due diligence, if there are any infringement due to some reasons, who pays? There have been cases when due diligence was done, but in spite of due diligence, you happen to infringe third parties' rights, then courts have been actually liberal in granting the damages. So damages, so due diligence is always preferred to be in place at the time of any litigation, and it is taken as like you have good faith, you have used the process, but you didn't have any ill intentions. So, so that's how initial due diligence helps.
I think we have one more question with us, and then we can sum up the session for today and close it.
Yeah. Last question is from Rekha Rao. Rekha, just type Indian Patent Office in Google, and the first link is Indian Patent Office website.
All right, Bindu. So if you would like to sum up the session, you can do it now.
Yes. Yes. So thank you so much, everyone, and it has been really nice to have this talk today. All the best. Thank you so much.
Thank you for the insightful presentation, Bindu. I'm really thankful to our guest speaker today for conducting this wonderful and informative webinar. It was indeed a great session. I would also like to thank all our participants for their support in making this webinar a success. The recording of the webinar will be available on techgig.com by tomorrow. Thank you all for joining us today. Thank you, Bindu, for all your time. Have a great evening ahead.
Thank you. Thank you.
Bye, Bindu.
Bye. Take care.